Whaitiri.
Thank you, Mr. Speaker. I want to respond to the chairman of our Select Committee in following his acknowledgement of the submitters, Mr. Chair. And I want to say that of the very broad range of submitters who came in front of the Select Committee, many of them opposed them, Mr. Speaker, including Local Government New Zealand, a great many regional and district councils. We had major land developers, including Fulton Hogan. We had major corporates, including Fonterra. Sir, we had infrastructural owners, including airport and quarry owners. We had all environmental non-government organisations like the New Zealand Law Society and numerous others, sir. Even among those, sir, who purported to support the bill, were guarded in their words, sir. They used words like, "We support the intent of the bill," before criticising much of its detail. Sir, I also listened to the Minister's opening address in this third reading of this important piece of legislation, and I follow on the point around getting, I guess, streamlining planning processes through national templates, definitely around standardising terminology, and I listened intently to the Minister's reasoning for why this has been brought in this bill. And then he stopped. And I was hoping the Minister would explain where taking and standardising templates and terminology then extends himself into the contents and the plan provisions themselves. That was the bit that I was hoping the Minister could explain why he feels the need to take those decision-making powers from democratically elected councils. That's what I was hoping that I'd hear, sir. But he never gave that. So what's the upshot? The upshot, sir, is local and regional plans are now out. And instead, we've got a national government propped up by the Māori Party's plans are in. So every council around this country should fear, sir, the communities that they represent, the environmental groups that they represent. Even the National Party children and their grandchildren should have real concerns around the protection of our environment, which is what the RMN is doing. And so the powers that my colleague David Parker spoke about in terms of the 360D and the overarching broad-based powers that the Minister, for me, sir, and for many listeners, I didn't think we got a justifiable reason from the Minister himself. And this is a fundamental issue with this bill as I read it. And I never heard from the Minister why he requires that amount of power in the RMA bill. That sends a clear signal out to councils: we don't trust you to do it yourself. We don't trust you to actually set these boundaries. Of course we want fresh water. Of course we want clean water. And actually the government can start by actually raising the standard of water quality from wadeable to swimmable. We can do that. We don't need this. We can do that. You can do this tomorrow. But no, we don't. We have given the Minister the powers to override local plans. And, sir, that is a sad day in this country when we do that. The Minister also made some statements during the debate of this House that this bill will help not only streamline planning provisions, will take out the confusion. And, sir, in the paper today, an article written by Gerard Hutchings of the New Zealand Farmer stated that actually the debate of this particular legislation, sir, is so important to New Zealanders that it's even watched overseas. And he made this point, that the law that we are passing will create a mess. That's his words, quote, a mess. It creates a lot of uncertainty which will have to be cleaned up. And that was taken and made by the Federated Farmers President, William Rolleston. That's what he said when he watched the debate of this bill while he was over in Rome, sir. So there are actually National Party's own supporters that have real deep concerns with this bill, that it is not going to lead to clarification and clarity for people out there in New Zealand. It's actually going to lead to a lot of confusion, sir. And mark my word, I actually believe it's going to lead to litigation. Right. It's going to lead to litigation. And when it goes to court, as the Minister well knows, they're going to actually take the debates from this House when proving their case. And I want to just take the House to that point, because when we were asking the Māori Party for the explanation of crops, sir, when we were asking either the Minister or the Māori Party what was meant by the definition of crops, we actually got two different answers. We got that it was restricted to cereals, fruit and vegetables. That's what we got from the Minister. That's what we got. And the Māori Party came back and said, actually, no, it includes grasses and forests. So when those parties, yes, you check.
A point of order, Grant.
So I apologise to my colleague Meka Whaitiri, but Marama Fox's repeated interjection that she was lying is outside of standing orders. There are many speakers' rulings on that, and I asked it to be withdrawn.
Before I deal with that matter, I'm going to ask Nick Smith to stand, withdraw and apologise for interjecting during a point of order.
Mr. Speaker, withdraw and apologise.
Marama Fox, did you use those words?
Yes, I did. I withdraw and apologise.
Mr. Speaker.
Onwards.
A bit of, seriousness might have helped. Before Meka Whaitiri starts again, it's probably I was going to interrupt her at the 2-minute bell, but just to indicate that the clock is running about a minute behind time on the advice of my predecessor in the chair. There were what he regarded as frivolous interjections earlier, and 1 minute will be added to her time at the end of her speech. So she actually has now almost 4 minutes to go. Meka Whaitiri.
Thank you, Mr. Speaker. As I was saying, I heard in this House two definitions when asked to define the exclusion clause that the Māori Party presented in the House. And I heard two different versions, sir, which isn't going to help those parties who only recourse to challenge the Minister's overarching plans is to seek remedies in the court. And that's where debates in the House are going to be cleared. The point I'm making is that there is some confusion. It won't lead to clarity, as the Minister purports. Which then leads me to the Māori Party. The Māori Party, who will have to stand and be accountable for the many kaitiaki around this country. In fact, one just returned back to the Napier port, having sailed out onto Mataua Maui to protest on the seismic ship. We're going to have to stand, the Māori Party going to have to stand and defend their position of supporting a piece of legislation that will allow the Minister to override regional and local plans. That's it. Can't say it any more simple. They're going to have to defend that position, sir. But when I listened for why the Māori Party in the secret deals with the National Party are supporting this bill, we got told iwi participation plans. That was the game. Again in this House, I heard from the member of the Māori Party that it included not just planning, but also consenting and monitoring. And I thank the Minister for getting up and clarifying that iwi participation plans only involve planning at the front end. Does not involve monitoring, does not involve consenting, because he said it remains with the Council. Sir, thank you, sir, 2 minutes. This is the humbug that we are getting from the Māori parties for their support of this plan. Iwi planning participation plans, which were already in the RMA, of which 124 hapu and iwi, sir, already have some arrangement with local councils. In fact, 83% of all councils throughout New Zealand, sir, have some sort of arrangement with local hapu and iwi, be it through memorandum of understandings or joint planning committees. So when you pull back the argument and the justification for why what deal has been done here, it's not obvious, sir. There has been no gain for iwi Māori because many of them haven't already. That's an earlier point made here, and there's confusion around how much input iwi are going to have through this clause, and the Minister has clarified it. All you're getting is what you already had. How is that a gain? How is what you already had, and it was already there, but you're getting it now, is a gain? That's where the Māori Party are going to be held accountable, sir. The other point, and I do want to acknowledge the work of the Select Committee, sir. We've had screeds and screeds, and I want to also acknowledge the officials that supported the Select Committee. Having 700 submissions and over 130 appear before the Select Committee, it was a very complex bill, sir, that we had to endure. So I do want to acknowledge the work of the officials in supporting us. But, sir, there is a real concern I have that when we are getting contentious definitions and terms in a legislation, whether it is the role of our PCO office to make that determination, or should it be done at the Select Committee? I believe it should be done at the Select Committee level, sir. And in too many instances in this bill, sir, that didn't occur, and that's unfortunate. But this is a bill that Labor is definitely not supporting, because the Minister hasn't outlined the support, and I thank the Speaker.
David Seymour.
I rise on behalf of the ACT Party